and how values can change depending on the community that you are in.
First as a Black woman, and then as a defense attorney.
Their cross-section because there's an obvious group of people, that distinct group that is missing.
That language that you should be using, because that's what the law says.
Currently, because of the overwhelming media coverage, any potential juror may have already formed an opinion about the case.
Members of the jury, shout out to Miriam Foy for that amazing introduction video. It's a true privilege to be with you all on this Wednesday where we get to have a conversation about jury service, about our country, about the Constitution, about our criminal legal system. My deputy director, Porsha-Shaf'on, is tuning in right now. We're excited to be here. We literally look forward to these conversations every month because Porsha and I, we chat about so many different things and we're like, oh, we should talk about that or we should talk about this. And here we get to have this conversation for you all to listen in on. And we hope that you take the things that we talk about in these conversations. You send us messages, you engage in the content, you challenge our thinking and we can challenge yours and we can have these conversations because we strongly believe that an informed citizen, an informed resident, an informed constituent is an informed juror. And that's what we want you to be. We want you to have the information you need so that you can participate in our democracy through the power of the jury box. So welcome to tonight's conversation. Porsha-Shaf'on, welcome. It's so good to see you. You know, I'm going to put you on blast for a little bit because you love to make us nervous with your timing. And it's great because every time I'm like, I know she's going to be here. You're just going to be right on time. And so as you are, it's great to see you.
In my defense, if you live in New York City, you know that Mother Nature just both blessed us and disrespected us at the same time. It got real ugly. So my humblest apologies to both the audience and you, but I was definitely on the bus that struggled getting here. I honestly did not know if I was going to make it. I am hot, my locks, everything is crazy. But good evening, everybody. I'm always ready to engage.
Good. So members of the jury, we have three things we want to talk to you about. One, we're excited to give you a little bit more insight into this thing called an amicus brief that we filed, not in the state court, not in an appellate court. Well, the Supreme Court of the United States, and it technically is an appellate court, but the highest court in the land, we, the Juror Project, filed an amicus brief on behalf of a juror who voted not guilty in the case, and we're going to dive into those details. We also want to talk about things that you all can do as members in our community of holding some of our courtroom actors accountable. So district attorneys, prosecutors that are in court, judges, and even, if there's issues that you're having with folks on the defense side of the bar, we can talk about that as well. And then I want to have a conversation about what are our rights when it comes to protesting, right? One of the most American things that we can do is protest. This country was inspired by people protesting a form of government, right? Protesting the laws and the lack of representation that was being instituted from the King of England. And so we want to kind of contextualize those things for you all and to kind of give you insight into what we've been up to and how our summer has been progressing. So first, I'm going to start with the amicus brief, right? So here it is in its glory, right? An amicus brief or an amicus brief. I'm going to ask Porsha-Shaf'on to just share with us very generally what is an amicus brief, and then I'll get into kind of why we filed this particular brief on behalf of a juror.
So an amicus brief to the Supreme Court, and Will, please correct me if I'm wrong, because I have, unlike you, a very limited experience filing amicus briefs.
The only other one that I've actually been a part of is the Second Amendment one to the Supreme Court that changed the laws. And so really an amicus brief is, and tell me if I'm right or wrong, Will, but it is in support of an assertion.
Yeah, that's right.
Is that right?
Yep.
And so basically, oftentimes organizations and or individuals join in amicus briefs to support a claim. So you have the original individual that lays out what the actual legal issue is, and then an amicus brief really lays out it. It really can be, if you're thinking of the human body, the amicus brief is often the heartbeat, right? It's the thing that really makes it flow and gives it power, because you are really telling other human beings about the lived experiences
Mm.
of other human beings.
Hmm.
Well,
Yeah, absolutely. And I want to add to that. So the term amicus brief or amicus brief is the full term is amicus curiae. I don't speak Latin, sorry, y'all. But the reference to that term is called a friendly letter to the court. And so, although the person who is having their brief filed, they're not like one of the parties in the litigation that's being argued in front of the Supreme Court. They have some relevant context or some relevant information or some relevant expertise that they want the Supreme Court to be familiar with to help contextualize their interpretation of the arguments that are being made in the matter that's in front of the United States Supreme Court. So I now want to give you the story behind this juror. So in 1996, there was a murder in, I believe it was in Tangipahoa Parish, and two people were charged with this murder. And there was a first trial of, I'm going to call the person James. James was originally charged with first-degree murder, and the jury came back as a mistrial or a hung jury. Porsha-Shaf'on, can you remind us, what is a hung jury? What does that mean?
it is always my pleasure to remind the community about what a hung jury is. It is literally when you have a group of jurors and they cannot reach a decision. And so as a result of them not being able to reach a decision, the judge calls a mistrial. And for many of us, that is our hope.
Well,
Next to the acquittal.
there you go. So the James is taken to trial the first time, and there is a mistrial because there was a hung jury. And I got to remind you all, before 2018, Louisiana did not require all 12 people to agree on a verdict. That's called a unanimous verdict. We allowed non-unanimous verdicts to convict people, and the threshold was 10 votes. So if 10 people voted guilty, the person would be found guilty, even though there were two people who voted not guilty. So James goes to trial the first time, and it's a mistrial. They then reduce the charge from first-degree murder down to second-degree murder. He goes to trial a second time, and on this second time, the jury votes for guilt, 11 votes to 1 vote for not guilty. And that juror voted not guilty because he had very strong issues with the theory of guilt that the prosecution was putting forward. So they were accusing James of being a driver in a car, and the allegations were the car was used to run over a young person that ended up dying. And this happened on a gravel road. And the juror basically said, look, I grew up on gravel roads, and I've fallen off my bike, and my knees have been bleeding. And when you fall on gravel road and you're bleeding, the gravel and the dirt stick to your skin. And so the prosecution was talking about this head injury on the back of the person who died's head, but there was no gravel. There was no dust. There was nothing adhering to the stickiness of the blood in the hair. And that was a big issue for the juror, because he's like, if you're saying this guy got ran over on a gravel road, on a dirt road, like, it just wasn't making sense. And so he ended up voting not guilty because he just didn't believe in the case. What ended up happening is there is a discovery of some Brady violations. And Porsha-Shaf'on, can you explain what is a Brady violation? Or what is a Brady obligation and what is a Brady violation?
So, a Brady obligation is when the prosecutor is required to disclose any information that goes against our client's guilt. So, basically, for example, let me just give you a regular, degular, schmegular example. Let's say that I think my man is cheating. And so, in the beginning, he was doing all the good things. And then my homegirl then points out, but he's doing this, he's doing this, he's doing this. All the stuff my homegirl points out is what a Brady would be. And so basically the prosecutor, my adversary, is supposed to give us all of the information that cuts against our client's guilt.
Thank you. So that was an issue in James's case, right? There was evidence that could suggest James's innocence that was not turned over. So the Innocence Project of New Orleans brings this case up to the United States Supreme Court. They're advocating on behalf of James's innocence. And it goes.
One thing that I want to note for the audience, though, Will, and I'm so sorry to cut you off, is
You
that, hiding Brady evidence, right? Not Brady evidence, Brady disclosures is really one of the worst things that a prosecutor can do, right? For those of you on the call that believe in the criminal legal system and its fairness and its duty, right, to impart justice and fairness, hiding evidence that goes to someone's innocence is one of the worst things that you can do next to hiding evidence. And, depending on the day, they are one and the same. I'm sorry about that, Will. I came late and I cut you off. I'm sorry.
It's all good. So the matter that's being argued is, should this conviction still stand when there has been the discovery of this evidence that was not turned over? So the Juror project was introduced to this juror who voted not guilty in 1996, and we had a conversation with them. They talked about why they voted not guilty then. And then we were like, look, if this evidence that was not turned over back then would have been presented during the trial, how do you think that would have influenced the deliberation process? And remember, deliberation is the word that we use to describe the conversation that takes place after the trial has basically been handed to the jury. So the prosecution has closed their case, the defense has closed their case, the judge has gone through their introductions, and so now the jurors are just in the room and they are deliberating. And this juror said, well, when I began to raise my concern about the lack of this gravel evidence sticking to the head, nobody listened to me because they didn't need to, right? They had their sufficient amount of votes for a conviction. Now, had this trial gone to place, taken place in New York, in Wisconsin, California, Texas, in 48 other states except for Oregon or Louisiana, right? It would have been another mistrial because it was a hung jury, or maybe not. Like if he would have had the power to continue the deliberation process, then the other jurors would have had to engage him in a conversation. But since they did not need his vote, they did not have to talk to him about his concerns. So what we were able to do was share the evidence that was not originally turned over, present it to this juror, get his perspective on how he thinks the deliberation process may have changed, and then represented that to the United States Supreme Court. Because what the Supreme Court is being asked to do is to overturn this conviction and basically afford this person, Mr. James, a new trial. And that new trial would be able to go forward with all the evidence and the Brady material that has been recently discovered. Now, I mentioned that there were two people who were charged with this murder. They were co-defendants. Defendant number one takes the case to the United States Supreme Court for those exact same Brady violations, for the exact same prosecutorial misconduct. And the Supreme Court calls those Brady violations or that prosecutorial misconduct, they say that this is egregious. Meaning this is a terrible example of the breach of duty and care that prosecutors are supposed to pursue justice with. So the first person has had their conviction overturned. They ended up accepting a plea deal for credit for time served, and they have been released. So that person's case is done. Now, Mr. James is like, look, same case, same Brady violation, same egregiousness. Like they're saying, this happened to me too. And, I'm optimistic. I've never done post-conviction advocacy. I've never had the privilege of being able to fight for somebody who's working towards an exoneration. But the fact that they overturned the first conviction for the first person gives me hope that they're going to overturn this conviction as well. Now, let me just remind people, if our system does not work for the innocent, it cannot work for the guilty. And I say that not to say that I think that the system that we have right now is the best system that we can think of. But I believe everybody believes and understands that no innocent person should ever be in prison for a crime they did not commit. Because that's an injustice on two different levels. One, it is an obvious injustice for the person who is wrongly incarcerated. And then two, it is giving people, the person who actually committed the crime is not being held accountable, right? So that we can't call that justice. So really excited that we were able to file this in the United States Supreme Court. We'll certainly keep you posted. We'll make a post to kind of give you updates in terms of what the Supreme Court decides. But this is a big opportunity for us to advocate on behalf of a juror in this manner to make sure the court understood why this person voted not guilty in 1996. And if the case was presented today, why the person still believes in Mr. James's guilt. So we wanted to share that exciting news with you all and really appreciate the interest in that work.
Absolutely. And so two things. One, one thing that I do want to head note is the system should absolutely work for those that are innocent. But I just want to be very clear too. We can't be willy-nilly about the process, even for those individuals that may have done it. Right? The process should still be the process, should still be the motherfucking process, no matter, if the person is innocent or potentially guilty, because we don't know what we don't know, right? And so we really do want to make sure that if there is supposed to be process, then there is supposed to be process. That's one thing. We do have a question, and that question from the community is, do we think that the case should be reheard with the new evidence?
My position is that this person has not had a fair trial because for two reasons. One, it was a jury that I think there were 11 white people and one black person in a parish that had more black people than just one person being represented on the jury. So I have issues with the jury that was assembled. But two, this person was wrongly convicted because the evidence that should have been turned over was not turned over. So I think that the person who has been wrongly convicted, it is up to them to decide whether or not they wanted to go to trial again or would they want to accept some type of a plea deal. And that's a really tough question, a tough decision for somebody to make, right? Think about, you are 100% certain that you did not commit that crime. And the district attorney says, look, you've been in prison since 1996. If you plead to manslaughter, we will give you credit for time served. We'll have you sentenced to 20 years and you'll be automatically released. And people are put in this position of deciding whether or not to maintain their claims of innocence or do they secure their freedom. And they're forced to make that analysis in a system that has traditionally not worked for them. And they have seen that system not work for them for the past 30 some years based on that wrongful conviction. It's a very, very difficult decision. So I hope that that person is empowered to make the decision that their heart leads them to make. And that if they do go to trial, that he actually has a representative jury and a jury of his peers. And also all the evidence that was not originally turned over is going to be in consideration for the jury to decide whether or not that person should be found guilty. I want to pivot a little bit, and thanks for that question. Our country has been having some interesting moments of what it looks like to protest and to demonstrate.
Diplomatic. You called it interesting.
Well, we have already established, Porsha, that I'm the diplomatic one.
You really are. You really are.
We all have different approaches. Sometimes I can be diplomatic, and sometimes I'm not so diplomatic, right? But thinking about, like, where does the power of protest come from, and what are our rights to protest? So, Porsha-Shaf'on, I want to invite you to kind of Share with us, what are your thoughts when we hear about people protesting and we hear about the reaction or the utilization of law enforcement to police, or even in some instances, criminalize that protest? What should people be aware of as it relates to their rights and their protections when they are exercising their constitutional right, freedom of speech, against their government?
So protesting generally comes as a reaction to some type of injustice, right? And oftentimes, people in a community, grassroots organizations, shout out to all grassroots organizations that organize these protests, but grassroots organizers often create a collective and individuals go out to the street, right? And because over the last, particularly, I'd say, actually, I'm not even going to give a number. Protests, often the benefit of protests obviously allow people to collectively have their voices to be heard about a particular issue, whether it's for or against a particular issue. You see that with the war in Gaza. You saw that after multiple murders of Black people throughout this country. And what's wild about what's happening right now, and I want to head note, all of the dope work that Harriet's Wildest Dreams and other grassroots organizers are doing in DC with protests and standing up against our government. What's happening now is law enforcement, and I just saw a video today on Instagram that was wild. And law enforcement is being deployed in Black communities. Now, don't get me wrong, y'all. That is obviously something that is happening every single day in Black and brown communities. So we used to surveillance. But what is happening is that law enforcement officers are being put into communities of color for the purpose of inciting anger, for the purpose of inciting violence. Protests are generally peaceful. And I'm not taking a position on, what's the more effective route, whether it be protests that don't involve going into stores and stuff like that. I'm not going to take a position about that. But normally, law enforcement are present at protests to just keep order. That is supposed to be what their function is. But throughout the years, that's not what we've seen, right? We know about the kettling that happened in the Bronx. And kettling is a medieval war technique, right? That was used on nonviolent protesters in the Bronx. And right now, again, in DC, right? And for years prior, law enforcement has been used to quell protests, to silence protesters, right? And the questions that we've been asked is what can the community do?
Can you, for those of us that don't know what kettling is, can you just explain that for us real quick?
Absolutely, and my apologies. So kettling is a war technique. If y'all have ever watched 300, if you watch fucking Game of Thrones, if you've watched any of these old ass war movies, your enemy surrounds you. They put you in a circle and they keep moving in, they keep moving in, they keep moving in, so that you are in the center and you can't move. But what kettling looks like in a Black and brown community during a protest is police and other law enforcement squeezing community members into a group, but you can't breathe, you can't move. Many protesters during the kettling that happened in 2023, I believe, or maybe 2022, but many of the protesters talked about the experience of being assaulted sort of on the outskirts by law enforcement that were directly next to them, people being sick, people not being able to breathe. It's a really terrifying and horrible experience. So my apologies for using that word, y'all, and not explaining it.
Thank you so much. I appreciate that. What are the rights that people should be aware of if they decide that they are compelled to go out and participate in a demonstration and participate in, what I would describe as something that's very American, right? Protesting our government for the decisions that they are making. What are some of the rights that people should be aware of?
I mean, you have a right to go into your community and make your voice heard. Now, folks often, there are communities in which lawmakers have tried to quell protests. So I want to urge people to know what the surrounding rules are in your particular community. And that means the time, place, and manner restrictions that can be in your community. And when I say time, place, and manner restrictions, I'm talking about as a protester, knowing the time frame in which you are allowed to protest. There are communities where you can't protest or you can't demonstrate after 8 p.m., right? The manner in which you can protest. Sometimes you can hand out leaflets, but you can't use bullhorns. Sometimes you cannot use bullhorns, but you can say chants. Sometimes you can say chants, but you can't use leaflets. The number of people or protesters or participants that are in the group can be limited in certain communities. And where the protest can happen. It is vital that those of y'all that are on the front lines, on the grounds, know, because what we always want to do is be in the right? And so if you are on a particular sidewalk and that sidewalk is not designated for a protest, that gives law enforcement a reason to engage you unnecessarily. Listen, I think y'all should do what y'all need to do when y'all need to do it. But I also want to keep community members safe. I want to keep those that got the boots on the ground, no pun intended, safe, right? And so this is important for y'all to know. And I will put my email in the chat after. And so if y'all have any questions, comments, or concerns about your particular area, I am happy to assist you because I'm well versed in both representing protesters and figuring out in different jurisdictions what are the time, place, and manner restrictions. So I will give y'all my email at the end. Actually, I'll just do it now. It's real simple. P as in Peter, S as in Sam, V as in Victor at thejurorproject.org. Reach out to me if you have any particular questions about your jurisdiction, and I'm happy to make sure that we keep you safe and out there yelling at the top of your lungs.
Two things. I will never be able to hear Boots on the Ground without thinking of the line dance, right? Which I love to do. But then secondly, people get arrested at protests. I remember when I was part of the demonstrations for Occupy Wall Street, right? This was, I don't know, 10, 12 years ago, 15 years ago. This was a while. People were arrested. And one of the strategies that were being discussed was like, everybody take your case to trial, right? And there's power in being able to say we're not going to accept a plea deal because we don't believe we did anything wrong. Now that's an easy thing to say, especially when people are being detained pre-trial, and recognize that you and I have represented people who have only pled guilty not because they were guilty, but because they wanted their freedom back. And that's part of the design of this system. Right. And that's why when people do get arrested, we have seen this more energy getting behind the bail funds. Right. And when people may not have the resources themselves to bail out, the community is like, that person never should have been arrested for that. So let's pool our money together and post bail so this person can fight their case from the street. So with that in mind, and thinking about, I really appreciate how you have given us guidance on like making sure that we're understanding the permitting issues or the restrictions. Like there are rules that kind of try to regulate demonstrations in a safe way, because not everybody might believe in what you're protesting against. People might be in support of it. And at the end of the day, we want people to be safe. Where can people try to find this information? I appreciate you sharing your email. For the people who maybe just want to go and look it up themselves, do you have recommendations of places where they could go to try to obtain that information?
Yeah, easy enough. Don't call me. So what you can do is literally Google the local ordinances surrounding protests in your area. That's literally all you need to type into Google. What is the local ordinance or restrictions for protests in this particular area? Whatever area you are in, you just need to type it in. Absolutely. One thing that I want to head note too is, I was just talking about safety during protests, and I want to just stay on that for 1 second. For for the protesters that are interacting with law enforcement, or that there's a possibility of interacting with law enforcement. The first thing, know your location. Share your location with other individuals before you turn your location off. There are differing views about whether or not to keep your location on during protests. If you are of the mindset that you are going to turn your location off during a protest, that's fine. But tell folks, give a blast to the general vicinity that you are in. Back in the day, because there was a concern about tear gas, I know that there were a lot of folks that were advocating to carry milk. That is no longer the way. Please carry water on you during a protest. Another thing, law enforcement often, if you're in the New York area and right now in the DC area, they are covering up their badges, their badge numbers, and their names. Again, that is why location is important. Oftentimes I see these videos during protests where someone is like, "Officer, what's your name? Officer, what's your badge number?" They will rarely give that to you. The police are not coming to these protests with an eye towards de-escalation. They are not coming to this protest with an eye towards support or keeping things organized or safe. I know that's what I said, that they're supposed to be therefore that's your right. I'm talking to you right now about what your reality is. And the reality is that more often than not, police are often escalating situations. So look at what the officer looks like so that you're able to describe him, right? Remember facial features. Stay calm. You will not be able to talk your way out of anything. Stay calm. Look around you. Look for vehicles that are around. Police cars often have numbers on them. No matter where you are in this country, police cars often have numbers, right, on them. Remember those numbers. Remember the numbers of the vehicle. Remember street names. Remember cross streets if you can. Remember landmarks, right? If there was a grocery store, try to remember. Use your energy for that as opposed to arguing with the raggedy ass officer that's got you in cuffs anyway. So yes, your right is to be able to protest without being bothered. But the reality is that it's a high reality, it's a high likelihood that you will be fucked with. And so these are some of the things that I'd like you to do to keep yourself safe and preserve your rights.
That's really helpful. You talked about a little bit earlier. You were talking about, unfortunately, the Black community's experience with being surveilled, right, and the hyper surveillance and the different forms it has taken. In New Orleans right now, there's what they call real-time crime cameras all over the city, and this isn't new. It's not unique to New Orleans. There's surveillance cameras everywhere.
They're definitely in New York,
right, in all these different cities. I want to call out some hypocrisy real quick. Surveillance is used as a tool of law enforcement. And when law enforcement are seen on camera beating people up, punching people in the face while they're handcuffed, doing all kinds of crazy things, that has been sometimes the only way that the officer has been able to be held accountable, because somebody was able to hold their phone out and record it. Right. There was the case out of South Carolina where Officer Schlager was arresting an elderly Black man, and I can't think of his name at the moment, but it'll come to me. And the elderly Black man runs away. He's like in his 50s or so. He's running away, and the officer shoots him in his back. The officer then walks up to the man who's dying, doesn't render aid, doesn't try to save him. The officer takes out his taser and tosses it on the Black man's body. And the police report said the man reached for my gun, tried to disarm me, and I had to use deadly force. It wasn't until, I don't know, a month or a couple months or weeks, whatever it was, later, that there happened to be a pedestrian kind of on the side of the park or the area where it was, standing by the tree and recording it. And it showed the truth that the officer shot the man in the back, that the taser was never attempted to be ascertained or obtained, and that the police report was a complete lie. Where I am going with this is once it emerged that surveillance could be used as a tool to hold police officers accountable, we saw legislation pass that creates a barrier of how far away you have to be in order to be able to record an officer. So in Louisiana, I believe it's 25 feet. Well, if I'm 25 feet away, I'm not going to be able to see a badge number. I'm not going to be able to see the nameplate, right? So it's just hypocritical that when it comes to the notion of quote unquote promoting public safety or accountability, law enforcement is okay with cameras being everywhere. But if and when those cameras get turned on them, they have an issue with it. And it's just inconsistent. We all know that people act differently when they're being watched. And unfortunately, in America, we see time and time again of law enforcement not acting the way that they're supposed to be acting, which is treating people like humans. And it's just really frustrating. And I think people are getting tired of seeing video after video of officers not doing the things they need to be doing. So I just want to lift up that there's this trend of laws coming into place that's creating a distance barrier in terms of how far away you can be when you want to use your phone. And if you're not in carpentry or you're not in construction, you're not eyeballing 25 feet, right? So it would leave for a good trial, because how are you going to prove I wasn't within 25 feet? But that's a conversation for another day.
And just on that point, just on the recording law enforcement while they are engaged in their duties, every single state, I believe, has a law that is codified that says that citizens are allowed to record law enforcement as they're engaged in their duties. And yes, but what most laws actually say in most states rarely have the number, the precision that Louisiana has, but they often say that you cannot interfere with the officer while they are engaging in their duties. So I just want folks to capture the moments, but again, also stay safe, right? Because while your right is to record law enforcement while they are engaged in their duties, I have seen time and time again, law enforcement use the fact that you are too close as a reason to arrest you now, because you've witnessed them doing something unlawful, or a reason to yell at you or to snatch your phone or to knock your phone down. Excuse me. Another thing that law enforcement does, particularly for those of y'all that are boots on the ground protesting, law enforcement will not come to you. Law enforcement will not say anything to you, but they will take their flashlights and put them in your phone. You know, I learned about this practice because I was at House of Blues in New Orleans during Essence, and Prince, during one of his last performances, made an appearance. And I kept being like, why does the security guard have their light up like that? And I realized it's a technique to prevent individuals from recording, or a technique to deter individuals from recording. And I've actually seen this done by NYPD multiple times. So that's just another thing for y'all to be mindful of while y'all in those streets.
Yeah, it's a way to interfere with the camera's ability to record. It kind of blinds it a little bit.
Mm-hmm.
I want to invite people to send us your questions. We're kind of coming to the tail end of our conversation this evening. We're going to dive into one more topic, and it's the topic of accountability and thinking about how do we hold elected officials that are in our criminal legal system accountable. Now, the district attorney is, typically going to be elected, unless you're talking about the federal system. Depending on the jurisdiction, a judge is going to be elected, not the federal system. That's going to be an appointment. But let's just kind of connect those dots. If you're in the federal system, it is the president of the United States who appoints federal judges. And so as you are thinking about the power of your vote, some people are like, I vote and nothing changes. Well, one of the things that is that if a vacancy presents itself during a president's term, they have the power to nominate a Supreme Court justice. A justice has to be confirmed by the Senate, and that person is going to be on the bench. And same thing in district court levels. The appointments come from the judge. So think about your political participation of voting for people who have life appointments, lifetime appointments, vote for the person that you think is going to appoint somebody that's consistent with your values. But let's talk about the state level, where a lot of states have elected judges. Some of them are appointed, but a lot of them have elected judges. District attorneys are typically elected. Porsha, what comes to mind when you think about ways in which we can hold those individuals accountable? And I want to include public defenders in this conversation, even though public defenders are not elected per se, right? Usually the chief defender is usually appointed. But we're talking about this courtroom work group, the prosecutor, the judge, the public defender. Talk to us about what accountability can look like for these very important actors in our system.
Sure. So the first one I'll start with are public defenders. You know, many of you probably don't know this, but there's a movement across this country, right, for participatory defense. And that is for defense attorneys to listen to the community, listen to the individual that's accused of the crime, and listen to their community and family members and those individuals that that they trust. Oftentimes defense attorneys can be incredibly paternalistic. And if you are on this call and you've ever been accused of a crime, or you have a family member that's been accused of a crime, you know how dismissive defense attorneys can sometimes be. So there's actually a movement across this country for defense attorneys to be more accountable to not just the individual that's been accused, but to the community as well. That's piece number one. I can't say the same for prosecutors because I don't know what they do except violate our rights. But one of the things that I can say is the way to hold prosecutors and judges alike, prosecutors, police, and judges alike, you already know where this is headed, get on juries. There is a high expectation of Black and brown people that the criminal legal system, right, the courts, police, prosecutors, judges, all the motherfucking state actors do what is just by us, do what is right by us, right? That is our expectation. And the expectation of us as Black and brown people is we don't participate enough in the system to have our voices heard, right? So they often are violating our grandmother's, sisters, uncles, fathers, cousins' rights, right? And they don't expect that person to go to trial. They expect to weigh that person down until they subsequently take a plea. They don't expect jurors to show up, right? Because socioeconomically, they may not want to participate, or they've had so many horrible experiences with law enforcement that they won't show up, or they don't want to be a part of it. So the way in which, one way, right, is obviously voting, which Will has already talked about. But the other way is to sit on juries. That is how you show police and prosecutors and judges how you want to be police, prosecuted, or judged, if at all, right? That's the way. And obviously by voting. But one way that is very tangible besides voting is sitting on a jury. If you believe that a law is unjust, nullify that bitch, right? If you believe that this shouldn't be a crime in this particular case or any other, nullify. And jury nullification is exactly what that man in Will's case, who he just filed the amicus brief for, did. He stood 10 toes down. Nullification doesn't require, although it would be amazing if the entire jury voted not guilty. But nullification is also an individual standing 10 toes down for what is right. So if y'all really want to hold people accountable outside of voting, sit on juries and let your voice and presence be heard. Nullify.
Thanks for that, Porsha-Shaf'on. I got a question related to this topic. What about qualified immunity? And I want to talk to people about a little bit what qualified immunity is and how it works. So qualified immunity is basically this principle, or the premise that prosecutors, law enforcement, actors of the state can't be held personally liable for the discretionary things that they do. It's basically a shield against liability. And there's been conversations about how do we pierce that shield, because if I can violate a person's rights and I can, have DNA evidence that exonerates a person and not turn it over, and I don't get held accountable for that, where is the accountability for me to not do that messed up behavior, right? If I, as a defense attorney, do something wrong, there's ways that I can be held accountable. And why are we so comfortable with this shield of protection for state actors as if they could never do any harm, which we know that they can? So qualified immunity is this premise that basically creates some protections and shields of liability for individuals who are essentially making types of discretionary decisions in their roles. Now, the 11th Amendment says that you can't sue a state government because you could basically bankrupt the system. So you can't sue an elected official in their official capacity. You would have to sue them in their personal capacity. So you would be going after their personal coin and not the coin of the government.
And
right.
You should. If Sally prosecutor saw the DNA evidence and she threw that shit in the garbage, you should sue Sally prosecutor. You should, please. You know, we be wanting to sue our neighbors for any other thing, for any other situation. Feel free to sue those mofos. But I just want to be clear too, Will, right? Qualified immunity doesn't mean that they can do any and everything, right?
Right. We think about the instances where immunity has been applied. We talked a little bit, I brought up DNA. I have to reference a case that many people are aware of, at least particularly in Louisiana. There's a man by the name of John Thompson who was accused and wrongly convicted of crimes in New Orleans. I believe he was accused of killing a tourist from out of town, or maybe it was a young business person. I forget who the victim was, but somebody did die, right? And John Thompson is accused of this crime, and he gets sentenced to prison, and he gets sentenced specifically to death row. At the time, the Innocence Project New Orleans was working on the case. I believe it was Innocence Project New Orleans. They identified DNA evidence that was in the file that should have been turned over, that was not turned over, and it was DNA from the decedent's, I believe it was the decedent's pants. There was blood on the decedent's pants that did not belong to the decedent, and it was understood that it belonged to the person who actually committed the crime. So that evidence gets tested, and it comes back, it is not John Thompson. And at the time that the Innocence Project New Orleans is emerging with this case and this matter, there is an assistant district attorney who knew that he didn't turn that evidence over. And this assistant district attorney is on his deathbed, and he confesses to another assistant district attorney and says, hey, you remember that John Thompson case? I withheld some evidence, and it needs to be tested, and it potentially can exonerate John Thompson. Now, I may not be getting the facts 100% accurate, but this is the gist of what was conveyed. What I will describe as the outcry witness, the person who received this confession, sits on that information for 5 years. And it is only when the Innocence Project is getting energy to say, actually, Mr. Thompson's actually innocent, then that assistant district attorney comes forward and confirms that the prosecutor who did commit the violation confessed to withholding this evidence, but that assistant district attorney is dead. So what does accountability look like? Well, John Thompson sues the Orleans Parish District Attorney's Office. It was under the administration of Harry Connick Sr. It goes up to United States Supreme Court. And I believe Mr. Thompson was awarded either $14 or $19 million, $1 million for every year he was on death row. And I apologize, I didn't review this case before our conversation, so I might get some of these facts wrong. Your friend, Justice Clarence Thomas, says, you know what? Lower courts, you awarding this $19 million or $14 million is not correct, because Harry Connick Sr., the district attorney, should not be liable for the Brady violations that are committed by his assistant district attorneys. So when we think about accountability, even when the violation is as egregious as withholding DNA evidence, proving somebody is innocent, we are still left with an inability to hold people accountable, which also gives government actors a false sense of accountability in terms of a false sense of deterrence in terms of not committing these types of violations, because it's very, very hard to hold them accountable.
And that's wild. You know, as we close out, I just want to say to the community, you know, I understand again, you know, that the system that we have in this moment is the system that we have in this moment. But that doesn't mean that we can't set fires. That doesn't mean that there is absolutely nothing that we can do. You absolutely can sue the prosecutor. And now look, I also understand that as Black and Brown people, we often get into law enforcement because we see that as a way, right, to provide for our family, to have benefits for our family. And so I dig that. But just because your daddy was a good daddy doesn't mean that he was an honest police officer. So I urge y'all to really think about, you know, what safety and community and accountability means. And the one, again, tangible way, right? I'm not just saying this as deputy director of the Juror Project. I'm saying this as a community member, as a Black woman that lives in these United States, right? As a Black woman that has Black men and Black women and Black people that I love, you know, that often have their rights violated. You can sit on juries and you can fuck this shit up if you so choose. It's why we do these lives. It's why Will created this.
That's what we got for y'all. Thanks for tuning in. Always enjoy the opportunity to speak with you, Porsha-Shaf'on. We're building momentum and it feels really good. So I want to thank all of you for tuning in, for sharing our information, for sharing our posts. We're excited to be doing this work, and it's really a privilege to be able to do it with you all. So thank you, members of the jury, whether you've been on one or not. We hope that you will be able to access the power of that jury box. And please tune in next month for our other conversation that will be taking place in September. Enjoy the rest of your evening.
Be on
We'll
time
next time. Yes, indeed, that you will be on time for. Catch y'all later.
Bye.